survey. We just ask that you complete that and turn that in so we can make improvements to this annual conference. And also, CLE certificates will be emailed to you this year instead of a paper. So we should have your email address. If not, you can stop by the desk out front and they'll make sure to get your email address, and we will email those out in the next couple of days. So we're going to talk about what everybody needs to know about ethics, and specifically I just call it how to keep your license. So I'm Scott Trout, and Barb Johnson-Stern, partner, our newest partners at Cordell, is also going to be joining me and taking the majority of this topic, as she prepared all of it, so I want to give her kudos. I am just copywriting her work, or copying off of her work. So ethics, I think one of the things, it can be very boring. That's why we obviously put it last, because there's nothing exciting. We don't have any fun videos. It's hard to find some videos that would be applicable. But I'll talk a little bit about why I think it's important, what we can learn from it. I think we want to try to create a little bit of a dialogue going among everyone. We'll probably toss some questions out to everyone. In fact, I know Frank and Barb and I were just talking about one of the ethics rules just out in the lobby, and I think all three of us had a differing opinion, and that's, I think, the interesting thing about ethics, is that you'll find everyone in this room may have something different to provide to the topic. And so for today's topic, we have taken the information from the 2012 report from the OCDC. They issued an annual report. 2013 isn't out yet. I've also got some numbers from 2011 that we'll go through just to kind of highlight what we're going to be discussing and how it applies to each of us, and why specifically it applies best to us in family law. So in excuse me, in 2012, interesting, there were 2,039 complaints. It seems like a lot, but in 2011, there were 2,278, and in 2010, 2,224. So you think about the number, but what I did was, and it's not on your slide, is I looked up how many licensed attorneys there are in Missouri. Anybody have any idea? I had no idea. Too many. I heard that. 28,000. It's a big number. So when you take the 28,000, you look at the number of complaints, it's only about 7.3% of the total number of attorneys. Now that percentage is a little off because obviously some of these complaints you have repeat offenders who are always getting complaints, and I think we all know, we see that. So it's probably a much smaller percentage than 7.3%. Of the 2,039 complaints, we'll talk a little bit about what happens with those, but 856, a formal investigation was opened, so a real small fraction. So of that, then the OCDC breaks it down, it goes to regional. Of the regional complaints, only 457 of the 856 went to a regional complaint, which represents only about 3.1% of the attorneys are faced with a complaint that is investigated regionally. Of the total 856, approximately 390 go on to the OCDC, representing about 1.4%. So it's interesting as you look, you have these complaints, but only the serious ones, the percentages continue to go down. And my guess is that 1.4% is even smaller, maybe even 0.7, less than 1% when you count the repeaters. So it's a small number. 48 were placed into formal resolution program, which represents less than 1% of the attorneys actually went through a formal resolution program, or 2% of the total complaints actually go to a formal resolution. So I mean, when you look at statistics and you think about chances, we all fear that complaint and we don't want to deal with it. It's good news, right? When you kind of look through a little bit more, and I dug a little bit deeper into the report, 12 attorneys in 2012 were disbarred. 12 out of 28,000. 3 of those 12, it was only by default. So really we're talking about 9 that we know did something that was sufficient or worthy of disbarment. 30 of our 28,000 members were suspended, and 3 of the 28,000 received a public reprimand. So it takes an effort to get disbarred. It takes an effort to have a formal complaint, or it takes ignorance. And so that's why I think the most important thing is that we go through this annually, and we just try to learn something and even communicate, talk about some of the issues, because it is a little dicey when it comes to certain issues. We were talking about attorney-client privilege, confidentiality, and what it takes with a waiver. And there's all kinds of thoughts on that process. So I thought that's why I would talk a little bit about more of the details and more of the statistics. But the good news, like I said, was it's only representative of around 7%. Here's the bad news. The bad news is that I think all of us in here, it's coming up, tax day, April 15th, we all fear being audited by the IRS. So I thought, okay, let me just compare the two. The chances of being audited by the IRS are less than 1%. It's actually 0.008% that you'll actually ever be audited by the IRS. But yet I would bet, if we thought about it, everyone here would mention, oh, I don't want to mess with the IRS. We give seminars around the country to clients, and we talk about financials. We know that they talk about financial statements, and you find clients will raise, if you give them a choice, what do you fear most? The completion of an income and expense statement or an IRS audit? They'll say IRS audit 9 times out of 10. But the point is that they're going to be audited, in my mind, 100% of the time on their income and expense statement. So they really should be more fearful of what they put on their income and expense. Likewise, you should be more fearful of being audited by the OCDC than you would by the IRS. Because we're talking about your livelihood, our ability to practice, our reputation. We'll talk about that, because that's one of the areas that you'll see in complaints is candor with the tribunal. Especially in this area, St. Louis, St. Charles, Jefferson County. As I mentioned, if your honesty and candor is in question, you might as well pack it up. I think it's a small enough bar that matters. Putting aside the fact that it is an ethics complaint that judges can file against you. So, good news, bad news. Good news is small percentage, bad news is you're more likely to get an audit, what I'll call an audit, a letter from the regional committee or the OCDC than you are from the IRS. So more details into the numbers. You have 968 of the complaints were never opened. They were filed with the OCDC and nothing was done with them. They were essentially dismissed on their face as perhaps not involving an ethics complaint or an issue with the rules of professional conduct. 94 needed further review, which means they likely fell into the 2013 numbers, so we don't know what happened to those. But you look at the numbers, it's a rolling number every year. It's probably a consistent percentage of those that need further review before anything is done. 125 had insufficient information, so in reality, they were probably kicked back, give us some more information about what you're complaining about, and then they were pulled back in either to the next year, 2013. Again, probably the same statistical significance. 96 referred to a fee dispute, and it's interesting, I think, at least from my perspective, I always think, well, that's a fee dispute, we don't have to worry about it, we can deal with the BAMSL Fee Dispute Committee. It's not an ethics issue. Well, it is. We'll talk a little bit about fees and why you have to be as concerned about fees as you would diligence, communication, contact with third parties, etc. 24 were referred to comprehensive resolution, and 27 were held in inquiry status. I call that purgatory. It's kind of like the worst place you can go, right, is purgatory, because you don't know where you're going, you're stuck in this inquiry status. You never want to go there. I'd rather have resolution. You don't want to be in inquiry and figuring out what's going to happen to you next. It'd be kind of the terrible position. So I thought that was interesting as well. As you look at the numbers, we all get this report, or it's all available to us. And I've never really dug into the report and read through it. suspended this week, who was disbarred this week. Do I know them? Did I graduate with them, right? I look at their bar number, see when they graduated, it's interesting. But I didn't dig into the OCDC report, and there's some pretty good stuff in there. We can all learn something to change the way we practice, to change the way we communicate, to make sure that we aren't just a statistic. So let's look about the nature of the violations and what it is that most commonly was seen last year, or excuse me, in 2012. Communication. 386 of the complaints dealt with communication. We're talking about return phone calls, status updates in writing, status updates when there's really nothing to update. I think there's some precautionary measures we can all take to ensure that clients feel that they're being communicated with, and especially in the area of family law, when emotions run high. Diligence, we'll talk a little bit about what that means, pursuing the case, timely filing. If you dig down into diligence, a lot of those numbers come from personal injury cases, where an attorney's evaluating the case, hasn't filed the action, doesn't file the action, those types of matters. But there are some family law issues within diligence that talk about the pursuit of the case. We're going to talk about requesting quick trial dates, pushing the matter, not delaying it. There's a whole host of complications when it relates to diligence if you do a flat fee. Are you dragging it out for the purposes of collecting more money? If you do a laddered flat fee, those types of things. So 334 came from diligence. Safekeeping property, 217. Excessive fees, 115. Remember I talked about fee disputes. Well, there we are. Excessive fees. It is a violation of Rule 4-1.5. So the standard that we have always taken, and should be everyone's standard, is your billing should be the lesser of what's actual or what's reasonable. So in either way, lesser of actual or reasonable. So reasonable is less, it's reasonable. If reasonable is more, you bill actually. It's the safest standard you can have when it comes to Rule 4-1.5. Dishonesty, fraud, deceit, misrepresentation. Obviously, those are really easy ones to identify. I would guess of the 856 formal investigations, some of those, the 83 is a big number. But if you look at the big three, I call, if you want to focus on, and your takeaway from today is the big three, which would be communications, diligence, and fees. Those represent 41% of all the complaints. Not to say that you should disregard the remainder, but if your practice is built upon those three pillars, that you ensure your chances of that audit probably get cut by 80%. And you can rest a little bit easier as you practice. Rule 4.1.16, improper withdrawal, and that happens more frequently than you can imagine. I used to read up, and many of you may do this every Tuesday, you get the slip opinions. There were a whole host of appellate decisions on withdrawal, the appropriateness of withdrawal, the timing of withdrawal, the notification on withdrawal, reasons. Those are all key. But if you don't follow and you don't do something timely, in advance of trial, you have to look at when's the trial, what is the damage that's going to happen to the client regardless of the reason for withdrawal. I would tell you to go ahead and pull some of those appellate decisions. They're very informative. They will guide you as to what you need to do in the event that you have to withdraw from that case. And I'm not talking about something where there's a conflict that's arisen where it's mandatory that you withdraw, or some sort of behavior, fraudulent or criminal behavior by your client that forces you to withdraw. We're talking about failure to pay, failure to communicate, something in those regards. But I think it's key. That is a huge one because 73 complaints on withdrawal. Something as simple as getting out of the case is a big one. Conflict, 67. Takeaway, make sure you look at your conflict check resolution program. What's in place if you have one? You have to have a conflict resolution program to do that. I think one of them, I talked about this a couple years ago, I think one of the more complicated scenarios for conflict checking is when you hire an attorney from another firm and trying to get all of the cases and clients that they've represented. When a client comes in the door, it's a pretty big problem. When they can't bring that information with them, the law firm may or may not disclose the number of clients they've had. So it's as simple as perhaps if you have a multi-attorney office is sending out an email with the retentions weekly, bi-weekly, that indicates who has retained and making sure that everyone reviews it. And if they recognize the conflict, you've done some diligence to do it. 35 on unauthorized practice of law. 33 on advertising, especially with the constant change of rules and our social networking, our internet, the rules related to what you have to do. I can tell you that when I'm listening to the radio, I constantly hear ads that don't comply with the rules, I think. My opinion. Not so clear, but I think it makes me worry. I think, if it was very clear, it would be a problem. Obviously, you have an obligation to report. But it just kind of makes you wonder. You have to read. If you're going to do the advertising, read the rules. Follow it. They're simple. There's some disclosures you have to put on there. And it's not terrible. I mean, there's some states that we practice in, Kentucky and Florida. Kentucky, you have to say this is an advertisement on every page on the internet, on every ad. Iowa, when you do an advertisement, you cannot advertise in a, what is the voice? A dramatic voice. It cannot be dramatic. It must be monotone. This is Cornell. So it's crazy. I mean, you think about it, and you can easily gloss over some of those things. But again, the goal in life for me and our firm is play by the rules. Simple. Don't make yourself a target. And life is much simpler that way. Competence. 23. We'll talk a little bit about competence. And I know that that's an argument we were having about the ability to take a case outside of your comfort zone. Truth to tribunal. 21. That's what I was talking about is candor, honesty. How you deal with the bench. Huge and important, because I always told some of the new attorneys that one thing you have, it necessarily won't be how your understanding of the law, how you try cases, it's honesty. It's what it is to me. It's how you deal with the bench and the bar. And if you can make that the focus of your practice for the rest of your career, it's a good one, no matter what. So 21 on truth to tribunal, which is a big number, surprisingly. Truth to third parties, 21. Not necessarily something that I think in family law we see quite often, but it is what it is. Confidentiality, we were talking about this outside, 18. There's a whole host of issues within confidentiality that we can talk about. I know Barb's going to address that. Supervisory responsibility, 7. And that one's a disturbing one for me because there are some issues, I think, that you can be a part of that you've done nothing. For example, nothing to violate the rule directly. So you can get called into the regional committee because a lawyer underneath you didn't do something that you may have told them to do. For example, judgment comes in, that lawyer tried the case that works for you. You sit down and you just talk about appeal. What are your thoughts on this judgment? Is there anything to appeal? Let's look at the rulings, let's think about it. And you say, yeah, I think there is. Why don't you go ahead and notify the client, give them the deadline, tell them what they need to do, how much it'll cost, how many days they have to notify us, what the timelines are to file the appeal. Lawyer doesn't respond. Lawyer doesn't tell client, right? So client decides to just call office and says, I haven't heard, is the judgment in? You find out and you panic, go to lawyer, and the lawyer says, oh, I forgot. Client files a bar complaint, you're on the hook because you're the supervisory responsible attorney. You told someone to do, and as professionals, we all think that professionals will do as they should and as they're instructed. You're still on the hook. That's a disturbing one because it's one where you didn't intend it. You actually took the appropriate action. You reviewed it, a junior or associate's work. You told them what to do. You're still on the hook. So, it's the trust but verify rule. You tell someone to do something but verify that they did it. Otherwise, you're on the hook. Criminal activity, 7, which is a good sign, only 7. Criminal activity, it's crazy. Obstruction, false evidence, 4, another one. You look at some of these, you think, someone said too many lawyers? There you go. There are 11 too many lawyers in this state with the criminal activity and obstruction of false evidence. Ex parte contact, 4. Prosecutorial responsibility, obviously, doesn't apply to us, but 2. So, as we think about what we've just covered, what do you think are I know we'll all know this, the number 1 area of practice with the most complaints? Domestic. Number 2? Criminal. And number 3, torts. Just, interesting. So domestic had 173 complaints of those investigated, or 20% of the actually formally investigated complaints came from our area. Big number. So now, if you look at the total number of attorneys investigated compared to the total number in our area, we should be a little bit more nervous. Because we're not just dealing with logical issues regarding ethics, we're dealing with emotion. We're dealing with clients that will file a complaint because they think you colluded with the judge, or back in chambers, you're selling them out. So there are a lot of things you just have to dot your I's, cross your T's. It's a big one. So, one of the things we want to do is look at some specific areas as it relates to some of the specific issues and the rules, so that we can give you a little bit of guidance. Again, I guess it is a little bit blah and boring, but I think it's worthy, and we'll kind of, again, toss it out. So, question under 4-1.1, which is the client-lawyer relationship. We talked about competence, and that's a big one. So the question is, I'm a family law lawyer. That's all I really do. That's all I do. I have done all kinds of other areas, but for the last 15 plus years, I think, only devoted to family law. My boss wants me to take on a breach of contract claim, or a client comes in the door and wants me to take a breach of contract claim. Can I? So the question is, and I thought about this a couple hours ago, I was just going through it, and I think the key words are, can I or should I? Those are two very different standards. So the answer really is, yes, you can, and that's under Rule 4-1.1 in the comments. Now, keep in mind, all the comments, I think, are on your thumb drive. All of the rules, the applicable rules are in your thumb drive, so you'll have them. You can refer to them, and I'm going to read a few of it just so that you understand kind of why. We argued about this and whether I should take it. It's really clear if a client comes to me and says, I have a patent case, will you take it or can you take it? The answer is clearly no. It's such a subspecialty. But the comments on the rule say, in determining whether a lawyer employs the requisite knowledge and skill in a particular matter, relevant factors in your decision include the complexity and specialized nature of the matter, your general experience, training experience in the field in question, the preparation and study the lawyer is able to give the matter, and whether it is feasible to refer the matter to an associate or consult with a lawyer or who is established and competent in that field of question. So it goes on to state that the fundamental legal skills consist of determining what problems are in the situation. A skill that's necessary transcends any particularized specialized knowledge, and a lawyer that can provide adequate representation in a wholly novel field through necessary study. The question becomes is, can you take it? Yes. Are you better off not? Yeah. I would certainly just farm it out, no matter how hungry you may be. Or co-counsel someone who can do it, because that's what the comments refers, getting someone who has the relevant knowledge. But to go further with that question, is can I charge my client for familiarizing myself with the relevant case or relevant law related to his claims? So what we were arguing out there is extreme to extreme. I know nothing about contract law. Let's just say I know zero. I've never handled one. I've never done a civil matter like that. Can I just charge my client because he wants me to represent him? Again, these are some words in play. I mean, who says, can you charge your client to familiarize yourself with the law related to his claims? Let's just show of hands. Who can say, yes, you can? And no. And the rest of you have no idea what we're saying. Well, the answer, surprisingly, And I question this, and it's a big caution, is yes. Under comment 2, it talks about you can do this and charge the client for it. Now, again, can I, should I? I don't think there's a difference. We were talking about extreme to extreme. There are issues that come up in our cases every day, perhaps, where you have to do some research because you want to find some cases that support your novel argument. That's acceptable. That's one extreme. And I think that is clearly acceptable, and there's no problem. We're not talking about the reasonableness of the fee or the charge. But on the other extreme is, you know nothing. Can you just learn, contracts for dummies? And even though the comments suggest you can, I just think it's a gray area. I wouldn't do it. They suggest that you can do it. Again, I think if you're going to, and your client is insistent that they want you and only you, I think you have to have a very specific acknowledgement by them of what they're agreeing to allow you to charge them. And be very clear in the representation at the outset, what it is that you're going to have to undertake and what it is they're agreeable to. And even then, I can tell you, I've seen opinions from the Supreme Court where if the client isn't consulted with another lawyer, they don't know what they're getting into, it's still problematic. I stay away from it. Unless you have dealt with those types of issues, I just think you don't. Yes?
There are some courts that will assign criminal appeals to attorneys when they are admitted to that court. Do you have any comments on that?
I know that it's like, well, I can tell you, here's a good example. When I was a new lawyer, and I thought it was the thing you were supposed to do, which was go ahead and enroll to be in the U.S. District Court, the Eastern District of Missouri, not knowing that I would get a civil rights case. I had no idea what I was doing, right? I got my civil rights case within a couple months, and it actually went to trial. Now, it turned out to be a really good case, but I think there are, and I don't know specifically, but I'm certain there's probably some immunity issues that you get when you're appointed by the court as it relates to malpractice. But from an ethics standpoint, I think you're clear. You're not charging your client. The state, you get your expenses paid, and I know you can negotiate a separate fee agreement, which that was what I did with this prisoner, was in the event of a judgment, you can negotiate some sort of contingency. But my understanding is that you can take it because you're appointed by the court. You're ordered to take it as a member of the bar. And I know some courts are requiring, based on a number of practice, that you take certain matters. And if you feel really uncomfortable, I think you have to address that with the court. And say, look, I don't know what I was doing. I was just talking about, I used to prosecute, but I wouldn't be comfortable taking murder cases. No way. I'd have to study, but again, you're not charging a client. But that is your obligation, your service to the bar. If the court feels that you're capable, you do it. And I think it's okay, though. Anyone else have a comment to that? All right. My client called me from jail. He has a bond hearing tomorrow and wants me to help. I've never done a criminal case, can I? So keep in mind the specific facts of this. He's not asking you to defend him on the charge. He's saying, I have a bond hearing. Can you help me? So the answer is cautiously yes. So in comment 3, it says, in an emergency, that's key, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation or association with another lawyer would be impractical. Even in an emergency, however, assistance should be limited to that reasonably necessary in the circumstances for ill-considered action under emergency conditions that can jeopardize the client's interests. So, again, you have to be cautious. If he calls you, it's after hours, you can't get someone. The bond hearing's at 8 a.m. tomorrow morning. It is just a bond hearing. If you want to go, you can, so long as you make sure you engage in a limited representation. We'll talk about that here shortly. Yes? Once you're in, you're in. Yeah. Right. Once you're in, you're in. That's the caution. That's why I said if you can get, now there are some of the rules allow now for limited representation, but that is the caution again. Once you're in, you're in. So that's why I said you can cautiously, yes. And I know in some of our other jurisdictions we practice, New York, you're in, you're in, you're in, you're in, never out, never out. Yes.
Actually, it's related to that. In Jefferson County,
At the end of the case, what we had done years ago, or what I did, I can tell you what I did with my appointed case in the federal court. It went to trial, we went to judgment, and I knew there was going to be some appeal afterwards. I asked the court to withdraw at that point because my appointment was officially over. They let me out. And I think that's the safest way to do it, is to not just conclude the case. I mean, Georgia, it's a very interesting area. When I practiced in Georgia, it is routine, no matter what, to always withdraw at the conclusion of the case. Because you don't want to be on the hook. Because what happens in Georgia, and Spencer, you get a phone call on a domestic violence, and you have about 2 hours to come in. They may just call you and say, well, you're on the case, you're coming in 2 hours. And you haven't been retained, you haven't been paid, you have to go in. So, I can tell you, I used to withdraw just as a matter of cause. And I think that's probably the appropriate thing to do. Do I have to do the entire case? Again, talking about scope of representation, which is interesting because of some rules with regards to that. I thought this was something worthy of review. 4-1.2, under client-lawyer relationship. My client only wants help with settlement negotiations. Can I step in? Now, I know that many of us have had this happen where clients come in the door, they say, oh, it's settled. Let me show you where it is. Oh, it's settled on this legal pad, by the way. And she's agreed to it all. Right. Now, do you want to get in? Now, I don't want to hire you to file the case other than unless it's settled. Or they give you the actually typewritten settlement agreement that perhaps another lawyer's done for them, and they want you to review it and advise them. Practically, or whether you want to do that again, should I, can I, totally different, I wouldn't. But the rules say, yes, you can do it. You can enter with a client and help them with settlement negotiations under Rule 4-1.2, subsection C, which says, a lawyer may limit the scope of representation if the client gives informed consent in writing, signed by the client, to the essential terms of the representation and the lawyer's limited role. Now, the thing that I think you have to be cautious with is you can't just explain it. You have to get a subsequent agreement. The fee, if you look at the comments to that rule, there is actually a sample of what you should be putting into that agreement if you want to do something like that. And I would follow it to the letter. That way you can say, look, I follow what the rules say, I follow what the comments suggested, I'm good. But I think that it is a problem, and I think it's perhaps more geared to defense attorneys who do an insurance defense, those types of things with plaintiffs cases where you can just negotiate and step in and do that. Do you need a special fee agreement? Of course, that's what we just said, 4.1 or 4-1.2, subsection C. You absolutely need that special agreement where it's very extensive. It talks about very explicitly the representation is limited. You describe what exactly you're doing, and I mean describe it. The lawyer does not represent the client generally or in any matters other than those identified in the form. As soon as you deviate from that, you go into that terrible trouble territory, where if you deviate from this review or just settlement negotiations, it's problematic. Now, it does not apply to an initial consultation with a lawyer or pro bono services, which is interesting. So, and services provided by nonprofits. My client wants me to help him engage in insurance fraud. What should I do? I guess it depends on what's in it for me. And then again, I'd be into those number 47 attorneys that are too many in the state of Missouri. I think we all know the answer to that. Absolutely not. 4.12-F, I know that's crazy, but I can tell you, we talk about clients who come in and say, hey, how do I hide my assets? And they whisper, how do I hide it? As if somebody else is listening. And I'm going to whisper back, I don't know. So a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. No news to us, but a lawyer may discuss the legal consequences of the proposed course of conduct with a client and may counsel or assist to make a good faith effort to determine validity, scope, meaning, or application of a law. So, you know, we talk about clients come in, and the one I always talk about asked me this question. He had inherited some rental property from his mother, and he wanted to hide all of the revenue. And I said, look, there's no need to hide it. Let's talk about the law. Let's talk about separate property. Let's talk about how we can get this revenue and keep the property. And I think he just went in one ear and out the other, and he didn't listen. And well, he went out the door, and I just forgot, and he came back and retained probably 6 months later, and I didn't connect the dots. I had written some notes about it, which a lesson. They're going to say something about it, write some notes in the file so you can connect the dots. Anyway, we wound up doing some things, and he was hiding assets and funneling money, and so it's not as if I gave him any advice, but the point is, the lesson learned in that is to take some notes in your initial consult, so that when they do come back, if they come back, it's a red flag. And you can counsel the client as to what you do. And I always tell clients, look, if your strategy, what you want, I can do a lot with what you want. There's not much I can't come up with a nice argument, a nice plan, unless it deals with child abuse or spousal abuse. Look, that's just stuff it's a non-starter. So anyway, it's clear, of course, we can't talk about those. In the same manner, my client wants to keep all the financial accounts. He wants to transfer them to a hidden overseas bank account. What should I do? I know that sounds crazy, but I have had clients not only ask me, but tell me that they've done that, right? So what do you do? At that moment, I will counsel them, and I will respectfully refer them to an attorney I don't like. So it says, we talk about separating objectives from means. What is, and that's referred to in this, and you think, what in the world does that mean? Well, how will we obtain a desired result? The objective and the means. So you can counsel, the comments say, the client has ultimate authority to determine the purposes to be served within the limits imposed by law and the lawyer's professional obligations. Within those limits, a client also has a right to consult with a lawyer about the means to be used and in pursuing those objectives. At the same time, a lawyer is not required to pursue objectives or employ means simply because the client may wish the lawyer to do so. So that's why it talks about separating objectives and means. Look, and the example I just gave you, let's separate the objective and mean. He said, I want to keep my property and the revenue. His means were, I want to funnel it and defraud the court. My means are, well, I can argue separate property. Separate those two, because they mix those with things that really shouldn't be done. I am too busy, and everyone is busy. We know that, and I can tell you early on in my career, I remember having 100 family law files. It was crazy, and I was a young lawyer, and lessons learned, and it's one of those things which get you in trouble. You may forget a court date. You may not notify a client. So this is a big one for me. This is number 2 on the list of complaints with the most ethics issues. Number 2, the client-lawyer relationship 4-1.3 and diligence. I need to slow this case down because I'm so busy. I can't go to court. I've got 3 trials next week. I've got 2 PDLs the next week, settlement conference. I have too much on my plate. Can I? No. The answer is no, you cannot. Because we've all been there. Family law, in particular, you can get a lot of cases in the door at one point. Or you're a solo or small firm and you have to. In order to pay the bills, you got to take as many as you can take. And it's a little bit crazy. But the comments talk about what you can and can't do. 4-1.3 says, comment 1, a lawyer should pursue a matter on behalf of the client despite opposition, obstruction, and here's the key, or personal inconvenience to the lawyer. That one bothers me a little bit because there are a lot of things that can be personally inconvenient. I've got a vacation set. I can tell you in Georgia, you don't get a choice. You don't go into chambers and the judge says, well, all right, let's set this for trial. Here's what I have. You just get a date, whether it's inconvenient to you or not, and you are showing up. Then you can file, what's it called? It's exclusion dates. Yeah, a leave of absence, they call it in Georgia. But the point is I think that's pretty important to your personal inconvenience. So that means you have too much going on, you have another case going on, you have to juggle it. And then it goes on to say, and take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. Note 2 says a lawyer's workload must be controlled so that each matter can be handled competently. For example, a lawyer may have authority to exercise discretion in determining the means, but he must have the ability. So, that means hire somebody, co-counsel, or decline the case. The thing I learned early on was don't take every case. You don't need it. It's too risky. I know that it's money in the door and you're pushing it out, but it's not worth your license. This is what you work hard for. You need to just turn it down. Or you need to hire an associate or a law clerk. That's the safest thing to do. Note 3 goes on to say, even when the client's interests are not affected in substance, unreasonable delay can cause a client needless anxiety. Sound familiar? And undermine confidence in the lawyer's trustworthiness. Family law. They should just write family law comment right there. That is true. What we have is, why am I not at trial? Why am I not in court? Why can't I get a judgment? Why am I not doing this? Why? It's like your children. Why? That's where you are. So diligence. That's why it's number 2 on the list. I would bet if we dug down into those 273 family law complaints, diligence perhaps would be number 1 within family law. Do I have to take the first trial date offered? No. You do not have to take the first trial date, but I think you have to have that caution, remember, with the word personal inconvenience. Because a lawyer should pursue a matter despite opposition. It goes on to state, the duty to act with reasonable diligence does not require the use of tactics that are aggressive, offensive, or to anyone. The point is you have to use your discretion. You can indicate that you cannot reasonably and competently go to trial on a day that you just can't do it. There are some exclusions to that, but it all comes down to, look, don't take more than you can handle. You won't have the problem about trial dates conflicting if you don't take on too much. What does my client need to know? So that is the number 1 complaint, and for my portion, that's where I'm going to end, because I wanted to go through the number 1 and number 2. The 4-1.4, the client-lawyer relationship, communication. It leads all complaints. My client just wants this to go away, so he gave me permission to settle this case. Can I really leave him out of it? Well, he gave you permission. He told you what you should do. I'll settle for $100 in child support, $100 in maintenance, 50% of the property, right? Let's say he's living in a dream world. You say, okay, I'll go try and settle it. You get exactly what he said. Every word. You get it. Can you settle it? Can you just, without calling it? Yes or no? Not entirely. The rules are a little bit ambiguous. Again, the distinction between can I or should I. It's like when you took the ethics test when you became a lawyer, I always thought about, the can I or should I. Avoid the should I's because it's like, there's some gray areas. It's can I. It's you shouldn't do it. I can tell you as a matter of practice what I do. If I'm engaging in any settlement negotiation and I have full authority to settle something, and I've counseled the client, and I go to the lawyer and we agree to the terms that my client gave me, I will tell the lawyer, look, I'm confident we got this settled, but I'm going to go double check with my client exactly, go through it again, and say, I want to go through this again. I want to make sure you understand what you're agreeing to before I agree to it. So it is not entirely because comment 2 in Rule 4-1.4 says the client should have sufficient information to participate intelligently in decisions concerning the objectives of the representation. For example, a lawyer who receives from opposing counsel an offer of settlement in a civil controversy or a proffered plea bargain must promptly inform the client of its substance unless the client has previously indicated that the proposal will be acceptable or unacceptable, or has authorized the lawyer to accept, to, or reject the offer. Even when a client delegates authority to a lawyer, the client should be advised of the status of the matter. So, that last sentence, first we were like, oh, okay, I can do it, and then the last sentence goes, I don't think I can. So that's why it is clearly not entirely, because the comment suggests, if the client's giving you authority to do it, you can settle it. The nice thing in family law is you have to have it in writing, you have to have it approved by the judge, they can back out because it got allowed to deny. That's the nice thing. But in reality, you're going to get an ethics complaint if you try to settle a case and you say, well, you gave me the authority orally, mistake number 1. client's going to do, I'm going to put in writing, saying, okay, this is the authority you gave me, X, Y, and Z. Here's what I think is good, this is what's bad, and make sure that everything's in writing. What is enough communication? What is? Depends, right? So if you look at comments 1 and 3, under Rule 4-1.4, there are some shalls in there, not should, not may. A lawyer shall keep the client reasonably informed about the status of the matter, promptly comply with reasonable requests for information, and consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows the client expects assistance not permitted by the rules of professional conduct. And a lawyer shall explain a matter to the extent necessary to permit the client to make an informed decision. So, what I think the lesson, everything that happens in the course of your career, you should be taking a note and change the way you practice to accommodate the rules, like bi-weekly updates, something in writing, updating the client constantly, phone calls. Nothing angers clients more than waiting for you to return their call. Have your assistant call them, update them. Even when there's nothing to update, just say, hey, John, I just want to call you and let you know I'm still waiting to hear from opposing counsel. I followed up with them, and I will update you tomorrow. Send an email. Hey, just confirming, I just want to let you know what's going on. And then don't bill them for both, obviously, but you're doing one to cover yourself. That is the lesson learned on communication. More is better. Definitely better. My client is going to hate the expert report and might do something stupid. Do I have to send it to him? So the question is and again, is obviously up for discussion, but not immediately pursuant to the rules, which is interesting. In some circumstances, Rule 6, or Comment 6 in Rule 4-1-4, a lawyer may be justified in delaying transmission of information, and here's when the client would be likely to react imprudently to an immediate communication. So that describes every single family law client I've ever had. So there is no exclusion for me, I just send it to them. I mean, I do, and I know it's terrible, and I know that's, for example, and I think it's a good one, why some judges don't rule from the bench on certain matters, because they would act imprudently. And it's better to receive in writing later when they can calm down. But I think it is important that time is of the essence. I mean, there's a whole section that rules of the Supreme Court rules about time. And it's one of the first ones. And so I think, even though it says we can, again, can I or should I would not delay unless he says, look, if I get this expert report and he says I am bipolar, I'm going to go kill him. Now maybe you want to hold off a little bit. So there are some reasons to do it, but I don't think that it is, even though it says we can, again, should we? Those are the two questions you always ask, can I or should I? And I keep repeating it. So my client is going to hate this letter, and I just don't want to deal with it. Can I toss it? Can I just throw it away and never say it? We're just going to act like this never happened. No, you cannot. So the point is, again, what we talked about, you can delay transmission by the rules. You can wait till the appropriate time, but I don't see a manner in which you can ever not send something. And I think the best way, one of the changes we made was everything in, everything goes out, no matter what it says. You may not like it personally because it may say something about you or your delay. It may implicate you in your failure to communicate. You gotta send it. Because that's the one thing that you're gonna get hammered on by the OCDC, is not sending all communication.